Okay, now for part two of the Breuder lawsuit against College of DuPage and four of the trustees. I'm John Kraft, this is Kirk Allen. We're Edgar County Watchdogs. I'll let Kirk start this one on number 49.
Off we go. How many claims are there in this lawsuit? 100 and some?
Something like that. Yeah.
This number 49. Defendant Hamilton's accusations were made with negligent and even reckless disregard for the truth, were unreasonable under the circumstances, and were not rationally related to the fulfillment of her duties or the administration of the college. In fact, when questioned by the Daily Herald, here we are again, Daily Herald, about the validity of any of the many accusations charged against Breuder in his administration of the college, as reported upon by the media, defendant Hamilton stated that a lot of it was political and an exaggeration. Yet the board has based Breuder's wrongful termination on these political and exaggerated accusations.
Well, as we will find out, truth trumps lies.
Every time.
Her duty as the elected official is to protect the taxpayer, make sure public funds are spent for public purposes and not for the purpose of protecting the president. Number 50, he claims that Hamilton's conduct resulted in severe damage to his professional reputation. And then he talks about multiple articles being published in several media outlets, including the Chicago Tribune, Washington Post, USA Today, and Inside Public Higher Education. And many of those articles portrayed Breuder as greedy, corrupt, unethical, and unprofessional. So
it's not just Hamilton that's making those claims?
Well, remember what we said the last one, is truth always trumps lies.
Yep.
Okay, and then he talks about Hamilton instigated such portrayals and started as a result of her wrongful conduct. Breuder has lost speaking and some consulting engagements. Didn't have anything to do with what he did. It's all because of what she did. Remember that? So.
Yeah.
And was declined an already. That's funny. Declined an already awarded alumni award from his undergraduate alma mater. And he has been shunned by the academic community, and rightfully so.
Well, you know, if he was declined that award, then they obviously saw merit with what was out there in the public domain. So,
I mean, they didn't just read it in the Daily Herald and said, well, we're not giving you the award now.
There you go. Oh, gosh.
Now is when he starts talking about Hamilton recruiting Mazzocchi, Napolitano, and Bernstein to assist in pursuing her personal and political agenda. So I'm sure she made phone calls and said, hey, can you help me fire this guy? Not, hey, can you help me, I'll help you get elected if you want to become elected, or I can assist you in becoming elected as your right as a citizen and a resident of the district.
We don't have those rights under Breuder's ideas here. Number 51. In or around February 15, Hamilton reported to the public and to various media outlets that she intended to achieve her goal of terminating Breuder's employment by taking over the board through the upcoming April 2015 election, and then acting to accelerate Breuder's dismissal.
How much did he spend on advertising? Public funds?
Hundreds of thousands of dollars.
200,000 or more?
Yeah.
So she must be pretty good for him to spend $200,000+ of taxpayer money to tell everybody how good the current board's doing, to try to affect the election, and still lose the election. That's funny. Okay, throughout February, Hamilton recruited potential candidates to run for the board. What? She's recruiting in February?
That's what it says.
When's the last time to turn in petitions?
I think they'd already turned
In
them in.
December.
Yeah, I think
December was the cutoff, but she's still recruiting in February. Yeah, and then by March, Hamilton had found and began public, and so she didn't find them until March, even though they filled out their packet in December. And they ran for election as a clean slate platform, primarily focusing on ending Breuder era corruption. That's and clawing back the $763,000 golden parachute. That's a laudable mission.
Yep.
That's a good mission to be on. Protect the taxpayer.
Yep, and that's how they got elected. You know, as far as what the primary focus was, it was to clean up the corruption. I think the ones that won the election are trying to do that. 53. Hamilton used her official position to promote and endorse the so-called Clean Slate platform. Hamilton attended several Clean Slate campaigning events in her official capacity, and on information and belief personally contributed between $80,000 and $100,000 to the Clean Slate campaign. On March 31st of 15, Hamilton participated in a televised interview that aired on CLTV's Political Tonight, in which she stated her endorsement of a slate of candidates who could help her clean up the college.
Okay, number one. Is it against the law to endorse people?
No.
Is it against the law to make campaign
No.
donations? Is it against the law to attend campaign events?
No.
Okay, that's it.
Any more than I mean, to clean up the college, yeah, that they all ran on that slate, so I'm not sure what the point is.
Okay, in April 2, 2015, Mazzocchi, Napolitano, and Bernstein were elected to the board. That's what I'm talking about. Without hesitation, they used their election to promote the false charges they had made against Breuder during their campaigns. On the night of the election, they issued the following press statement to the press, claiming that tonight they were given a clear mandate to clean up the college, to finally stop the waste, fraud, and abuse. Well, obviously, with the number of votes they got, I would say, yes, they did have a clear mandate to clean up the college of DuPage.
And thank God we finally have elected officials, 3 of them, that are going to actually do what they said they were going to do when they ran.
Exactly. I mean, what's next? Next, Hamilton seconded their statement, commenting on CBS. So they motioned with their statement, she seconded. So she seconded their statement, commenting on CBS Chicago. I'm absolutely thrilled. I just feel the community has spoken. They've spoken out against fraud, waste, and abuse, and they've spoken for good government.
Yep, that's what they said.
Exactly. I didn't know you could base a lawsuit on that. Hey, more power to them. You're next.
Ironically, since the election, defendants Hamilton, Mazzocchi, Napolitano, and Bernstein and the Clean Slate Political Action Committee have had 5 complaints filed against them collectively with the State Board of Elections for violations of campaigning disclosure requirements. In addition, on April of 15, the college's internal auditor, oh I love this one, issued a report finding the defendant Hamilton endorsement of the Clean Slate candidates violated the college's ethics policy, specifically through her participation in prohibited political activity in her official capacity as vice chairman of the board.
You know, that internal audit was a sham. I'll say it was a sham. It was probably directed by Breuder to end that way, or McGuire. The people filing complaints against them are on the side of Breuder and McGuire and Aaron Burt. So you can, we could file lawsuits against, we could file complaints with ARDC against any attorney.
Yep.
Doesn't matter if it's true.
And some of these have been, I know Frank Napolitano's case has already been dismissed. There was no finding of wrongdoing, but you won't find the media reporting on that one.
No. Okay, now it goes into the indefinite administrative leave. He says that, yeah, they placed him, began their terms as trustees, and then late afternoon of April 28th, he got a letter talking about proposed agenda, special meeting, placing him on paid administrative leave. The letter threatened that if Breuder did not implement the enclosed agenda, disciplinary or other action would be taken against Breuder. Well, they're saying, do your job or we're going to take disciplinary action.
Right.
Something wrong with that?
well, for him, yeah, nobody's ever put him in his place before.
You got the next one.
April 30th, 2015, about 7:20 p.m., an organizational meeting of the board took place pursuant to Section 3-8 of the Act, I'm assuming the Community College Act. At the meeting, Defendant Hamilton, Mazzocchi, Napolitano, and Bernstein nominated and voted each other into office positions. Defendant Hamilton was appointed chair, Mazzocchi appointed vice chair, Defendant Napolitano appointed secretary, board trustee Aaron Burt, Joe Wozniak, and McGuire voted against each of these appointments. So what's their point?
Nothing illegal with that. They got the majority, they can vote how they want.
But let's waste a whole, 5 lines of a paragraph of a lawsuit in the federal court system to outline that they did exactly what they were constitutionally elected to do?
So then they started their meeting, pursuant to the agenda pushed through by Hamilton, Mazzocchi, Napolitano, and Bernstein. Well, they didn't push it through, they said, here's the agenda, that's what we're using.
Posted legally 48 hours in advance
Yeah.
in an open meeting to the public.
And then, yeah, they voted to place him on administrative leave. So. that's-
Next one. Hamilton commented to the public that the College of DuPage has been through tough times marked by extraordinary and continuous denial. Those troubles are not yet over, but the cause of those troubles are. Defendant Hamilton was unmistakably and maliciously referring to Dr. Breuder as the cause of the college's troubles.
I would say it's a pretty truthful, factual statement.
Yeah, it's pretty accurate. I think there's more than...
Of Hamilton's, not of his.
Yeah, there's more than substantial evidence to support that, yeah, that's probably the case. He's responsible for it. Besides, it was a public meeting. She can say whatever she wants. It's protected speech in a public meeting.
Then he said they adopted a resolution. Adoption of that resolution violated his January 2015 agreement, employment contract. Well, that was declared void.
Yeah, so he didn't have a contract.
No.
He keeps defaulting back to this contract. It was declared void.
And it was not unauthorized by any contact provision.
I love this next one. The board's adoption of the resolution was not authorized by any contract provision, statute, administrative rule, or board policy governing Dr. Breuder's employment. Nope, it wasn't. It was authorized action with the full weight and support of case law from the Illinois Supreme Court. How convenient they left that out.
Yeah, it was. He talks about lacking any rational basis to adopt the resolution, and it was frivolous and motivated solely by their personal and political agendas. No, they can't. Is it against the law to fulfill the campaign promise?
And frivolous and unfounded, how do you have, upwards of, what are we at, 8, 10 subpoenas?
10 subpoenas, yeah.
From the feds. They have to have probable cause to issue those subpoenas.
10 subpoenas being placed on probation.
With the Higher Learning Commission.
And the other probation with the, I can't remember the name.
Physical therapy program.
Therapy program.
I mean, there's more wrongdoing than shake a stick at.
And then with the Suburban Law Enforcement Academy, that's a whole other thing, too.
But he didn't do anything wrong.
No.
Alright, the next one. Resolution followed months of false accusations and slanderous statements made by defendants Hamilton, Mazzocchi, Napolitano, and Bernstein that charged Dr. Breuder with unprofessional, here we are again, unprofessional, unethical, and criminal conduct. Defendants Hamilton, Mazzocchi, Napolitano, and Bernstein's accusations were made maliciously and with negligent and even reckless disregard for the truth.
Well, elected officials' speech during public meetings is protected.
And everything they've said is supported by the evidence.
That's right. So what's he say next? Their conduct was unreasonable under the circumstances, not rationally related to the fulfillment of their official duties or the administration of the college. Well, yes, it was. Directly related.
Yeah, no doubt.
Then he claims that he wasn't afforded any opportunity to respond to the accusations or comments. Wasn't afforded the opportunity to present reasons as to why the resolution was inappropriate. Didn't he waive his right to hearings when he didn't show up to the meeting?
Absolutely. And he claims he was banned from coming on campus. Well, as an employee, they may ban you from coming back to work, but when there's a public meeting, they can't ban you short of a court order. He could have come to that meeting and gave public comment just like anybody else. Surely he's not that stupid to not know that, is he?
Well, he's claiming he is.
He waived his rights by not showing up to the meeting.
Then the board ordered him to not respond, distribute, or release any statement or communication orally or in writing with the media until further notice.
Wait a minute, which board?
On February 25. So that was the old board.
That's the old board. So now he's complaining what the old board did? He didn't name the old board.
Yeah, and then they lifted the order on April 2, but only permitted him to speak with the college's public relations consultant. Well,
That was all actions by the old board.
yeah, that's right.
Every bit of it. Interesting. What do the actions of the old board have to do with this?
Nothing.
That's a big screw up, but you know, that's a case where we're gonna throw stuff in here and we hope the judge doesn't catch the little things like that.
Yeah.
That's what that is.
Well, and then he says adoption of that resolution was grossly unfair and damaging to his reputation. Well, I think he did all that by himself.
No doubt.
What's next? Now he claims they all devised a plan to terminate Breuder in contravention of contractual and constitutional rights. Well, no. I believe when that 4-year late Attorney General opinion came out, plus other items.
You mean like that Edgar County Supreme Court case law?
Yeah. Coincidence, but it was good.
Yeah, that was good.
So then they said, following the adoption of that resolution, they immediately began devising a plan to terminate his employment.
I wonder if they've got a copy of this plan that they claim was put together.
Probably not.
Well, he had no contract, they declared it void, did it with case law to support it. That means he has no contractual rights.
That's right. And then they hired a law firm to represent the board, including matters related to Breuder's employment. And then he complains because they voted on and approved by their majority vote to have another law firm conduct an internal investigation. Is something wrong with that?
Again, they're exercising their duly elected duties. Now this next one, I did some digging on this one. This was really interesting to read. He claims that these resolutions violated board policy 5-30, 10-60, and 15-25, as well as Illinois Rules of Professional Conduct 1.7, 1.8, and 1.9. These resolutions also had the effect of violating Breuder's constitutionally protected rights. Well, adopting the resolution did not violate the ethics policy 5-30, nor the purchasing policy 10-60, nor employee code of ethics policy 15-25 as they claim. When you go back and read those, it's pretty ironic. That last one specifically, it points to a key provision, quote, no officer or employee of the college shall use or permit to be used college equipment, materials, services, or other property for personal benefit or profit. Wasn't that what Breuder did?
Yeah.
But he's claiming the board violated that.
Personal benefit to get sloshed on the public dime. We'll take a break. We'll get back with you.